Well, welcome back for the third unit. And for those of you who are reasonably observant, you'll see I'm back at my home office. Welcome to my humble home office. I won't bore you by showing you the craziness that's around here because right now it's a bit messy. The last video obviously was done elsewhere. Actually, while I was on a short vacation in Cleveland. All right, so Unit 3, we're going to talk about some things related to handling the actual negotiation itself. One of the things the book talks about quite a bit is power in a negotiation, and I do want to talk about that a little bit. So I'm going to break my rule just a bit of not parroting the book. A couple of things I do want you to think about. One is that perception does matter. I think I've already mentioned that somewhere along the way. Maybe I did the Doug Henning impression, perception is reality and reality is perception. And if you don't know who Doug Henning is, and most of you probably aren't old enough to remember him, just go online and you'll find him, and you can get him on YouTube. I remember working for this fellow one time, and we had this rather large case. And he told me that when I went to this hearing that he had sent me to, that I was to explain to the attorneys on the other side that I was going to be golfing all weekend, the upcoming weekend, before a very substantial hearing was to take place, and that Larry, my boss, would be out of town. And his point, I think, was to impress upon them the idea that we were already prepared for the entire case and that we had so little left to do and so little preparation left that it was completely unnecessary that we spend our weekend doing anything other than just enjoying ourselves. Now, what was the point? Well, the point was we were engaged in pretty intensive negotiations, and it was a fairly big case with a substantial potential settlement value and substantial potential verdict value, quite frankly. And so it gave off the vibe, I guess, if you will, that somehow we just felt uber confident. At least that's what I think my boss intended. Did it work? I don't know. Don't know. That's just the point, that perception does matter. And if nothing else, my boss understood that idea. My current boss is a young man, quite a bit younger than me. In fact, young enough to probably be my son. And one of the things he likes to say is erratic behavior is a powerful weapon. And he's right. He's right, because when you are negotiating with someone, sometimes erratic behavior, irrational behavior, strange behavior causes people to become concerned that they don't know what you'll do next. And that strikes fear oftentimes in the other side, because they're concerned about not knowing how to control whatever risk it is that they're worried about. And look, both sides on a negotiation, side A and side B, they are both concerned about risk. What's going to happen if this doesn't get done? What's the best alternative I have? The BATNA, B-A-T-N-A, you'll see that throughout the literature. Best alternative to a negotiated agreement. The other thing you'll see is WATNA, W-A-T-N-A, what's the worst alternative to a negotiated agreement? And so there's this idea of putting those two things together. Erratic behavior sometimes, or irrational behavior sometimes, might force people to reassess the risk that they're taking. Some things that you might want to think about in terms of sort of molding the negotiation is listening very, very carefully to what the other side is saying. You may pick up clues as to what things are kind of factoring into their understanding of the situation, as well as outside pressures that are on people. I can recall sitting, this was not a negotiation, but at a deposition, and this attorney was getting visibly nervous because it was getting later and later, and the deposition wasn't ending, and you could tell that he just wanted this thing to be over with immediately. And finally, it got to a point where he said, look, my kid's got a pee-wee baseball game or whatever it was, at 6:30, and it's now whatever time it was, 5:48. I'm leaving. And, we all kind of said, well, fine, go ahead and do whatever you're going to do, but we're going to continue the deposition until it's over. And he said, well, I don't care. I got to go. And quite frankly, we weren't quite sure what to do. We said, well, look, let's see if we can't wrap it up in the next 5 or 10 minutes, and will that be sufficient? And he said, well, yeah, if you can get it done in the next few minutes, I could probably work it out. And so shockingly, the deposition ended in like 7 minutes or something like that. I don't remember precisely, but it ended fairly rapidly. Again, sort of, that had nothing to do with anything. But the pressure was that he had some other commitment that he felt very seriously about. Keep those cues in mind. If you're listening carefully, sometimes people will say things like that, and you may find out that they're under other pressures that are even outside the negotiation. That gives you, as the other negotiator, that gives you some power. Time constraints, well, I guess I've just talked about that. Other time constraints, legal time constraints, always do kind of create authority or power on one side or the other, depending on what those time constraints are. And so use them wisely if they benefit you. If they don't benefit you, that is, if the time constraints are going to hurt you, then you've got to come up with a solution as to how to make them either less meaningful or to make it seem as if you're not concerned about them, or somehow you've got to come up with a way to manage the idea that those time constraints are really a pressure for you. One thing that comes up all the time are statutes of limitations. Of course, if you are the party on whom that is going to be a problem, you obviously want to, maybe you say, look, you know what, I've got my lawsuit ready to go. It's ready to go. I've got everything ready. I got the checks written to file it. I can walk down to the courthouse tomorrow, so that I'm really not worried about the statute of limitations running on me, even though it runs in 2 weeks or 3 weeks or a month or whatever the time period is. I don't care. That's all prepared and ready. It will take me 5 minutes to get it down to the courthouse. There you go. Right? Problem solved. Let's talk a little bit about some other general ideas that you're going to come across during a negotiation. And these are things that you will deal with regularly with negotiators. Agenda control, that typically isn't a big deal in a simple negotiation because the agenda is pretty well known. If it's a personal injury case and you've got a defense attorney on one side and you've got the plaintiff's attorney coming in on the other side, right? The agenda is, we've got a case, are you going to pay me some money or not, right? Other circumstances, there may be a more diverse agenda because there are more players. Maybe you've got a case in which involves multiple defendants. Maybe you've got a situation where you've got a negotiation relating to a business deal that involves multiple entities, not just the two that are trying to make the deal, but also maybe entities, governmental entities, for instance, that are going to factor in here. That creates a need for actually more of an agenda. Some people will try to control that agenda completely and entirely. Other people don't care. It's a good idea to at least have some input, particularly if you've got a sophisticated and detailed negotiation, and in fact you're going to want to have some kind of agenda. Negotiation site and the physical arrangements at the site, the number of negotiators, all these things are variables which you should automatically, quite frankly, decide are meaningless to you, okay? If they want you to negotiate at their place, great, because guess what? If you don't like what's going on, you can walk out. Think about it. You can't walk out of your own office. So if you're irritated with the whole process and you walk out of your own office, you look kind of stupid. Don't worry about the number of negotiators. I don't recommend the movie Erin Brockovich because the language is very foul, okay? And I'm not in favor of that kind of language, quite frankly. I mean, it sounds silly in this day and age, but I don't care for it. But I will say there's a scene in that movie which is fascinating. The bigwig corporate lawyers show up with their 4 lawyers, and the one lone lawyer, the Erin Brockovich lawyer, decides he's got to bring in some people to balance the scales. And so he gets like the guy who, I don't know, drives their messenger guy. He brings in a secretary and he brings in Erin Brockovich, his paralegal, and they all sit in there just so the score is even. That's totally unnecessary. Okay, the number of negotiators is should be irrelevant to you. Your case is what it is. Your situation is what it is. If they have 3 people, fine. Good for them. Don't let it intimidate you. Same with the place. Same with the physical arrangements. If you've ever seen the movie It's a Wonderful Life, now I will recommend that one if you haven't seen it. There's a scene in that movie where Mr. Potter is offering George Bailey, the hero of the movie, a job, and George Bailey sits down in this chair across from Mr. Potter's desk, and he like sinks down, way down, and the whole point, from Mr. Potter's standpoint, is it gives him power because he's looking down at everybody that sits in that chair. Don't let that intimidate you or bother you. Shrug it off and move on. Credentials. Sometimes attorneys will start throwing credentials out at you. I had an attorney years ago when I was a pretty young lawyer, out 4 or 5 years from law school at the most. And I was going to be trying a case, and the case involved a computer program and whether my client had properly put together this computer program, and the company that he did it for had not paid him. They were claiming he didn't really do what he said he would do. He was claiming, look, I wrote all this code. You owe me X thousands of dollars. And this attorney was walking around the courtroom before this trial. We were talking about potential settlement, and he was talking about, yeah, I was just in the Supreme Court last week talking to Justice so-and-so, blah, blah, blah. Well, frankly, I got intimidated, and I probably settled the case for less than I should have. Now, I had dealings with that attorney later on, down the road, and I reminded him of that event and told him no more. I specifically told him, I said, I remember that, Mr. X, and that's not going to bother me again. Just want you to know, you can't pull that card. You pulled it on me once and you got away with it. Good for you. But it's not going to happen again. And he said, all right, okay, you got me. Be careful about that, and don't let that bother you. Somebody pulls out their credentials, just let them talk. Okay. What are some other things that you'll have to deal with during negotiations? And by the way, I do quickly glance at my clock to make sure I don't go too long. This one's going to go a little more than 15 minutes, and I apologize. I'm really trying hard to keep these as short as I can so that you're not bored out of your mind. I haven't gotten sophisticated enough to bring in all kinds of other visual aids and that sort of thing during these videos. And so I know just me talking as sort of a talking head isn't terribly exciting. Some of the other things you need to think about: what happens if you cooperate? Oh my goodness, heaven forbid, right? You actually cooperate, and that you are actually giving in, right? And you've got to consider that throughout. Of course, the client, if you're dealing with a client and you have a client, or if you are the client, right? You always are considering what's in the client's best interest. From a legal standpoint, that's paramount. And early on in the course, we talked about Rule 1.2 of the model rules, which pretty much are the rules that are across the board around the country now. You have to get the client's consent to settle anything, and so the negotiation has to end with the client's consent. And so that's something to consider throughout. What are the community expectations, for instance, and what are the client's expectations? By community, I mean, if you're in a legal community, you're in a legal community. And no matter how you practice, if you practice law, or if you work with lawyers, or if you work for lawyers, there is and some of you I know do, you either work with or for lawyers right now, there's always a community within which one practices. For me, for many, many years, I was a defense attorney doing insurance defense in a community of personal injury lawyers. And so I knew all the personal injury lawyers of substance in Tidewater, Virginia, otherwise known as Hampton Roads, Norfolk, Virginia Beach. Thus my connection to Regent University, by the way, where I taught actually on site for a number of years, because that's where I lived. I lived in Newport News, in that general vicinity. Now, I got to know all the big players, all the TV guys, I knew them. Okay, and I tried cases with many of them over the years. And so that got to be the community. Well, of course, the other group of people I got to know were the other defense guys, the guys who did the same work I did. In fact, I got to know them probably better than a lot of the plaintiff's attorneys, interestingly enough, because I would see the same defense attorneys pretty regularly on cases. And so And it's not a big group. And so we kind of all knew each other for the most part, and got to know each other, sort of how we worked, and you got to know whether so-and-so was easy to deal with, hard to deal with, were they tough negotiator, were they trustworthy, all those kinds of things, and that all factors in. Clients sometimes don't understand that when you are pals, quote unquote, with the other attorney, they don't get that that has nothing to do with how you're going to conduct yourself. In other words, sometimes because you're in a group, in a community of lawyers, or in a community of negotiators, whatever it might be, maybe it's real estate agents, for instance, you get to know each other because you see each other fairly regularly. And so and you need to let the client know, look, just because I'm friendly, as one old attorney told me long, long ago, you can agree without being disagreeable. And just because you agree without being disagreeable doesn't mean that you just are rolling over. You don't have to be disagreeable. And you can come to resolutions and things. So clients need to be aware of that. Expectations need to be managed throughout the negotiation. Be careful about emotions during a negotiation. That can really skew things, particularly if one of the negotiators gets emotional. That can be a real problem. I don't know that I ever found myself getting terribly emotional unless it was on purpose. And typically when I got emotional, it was because I was getting righteously indignant about some issue in a case and making it known that, by golly, my client was clean, had clean hands, and was really the client who was being done a grave injustice and that kind of thing. So I won't say it was feigned, because if I said it, I meant it, but it was certainly not emotional in the sense that I was just sort of losing control. That can happen even with professional people, and you need to be aware of that and concerned about that. Just keep that under control. What do you do to get things moving towards a resolution? Well, one, sometimes you just have to say, look, I'm going to take the first step, and you do. And you throw it out. Look, I'll throw it out there. Okay? I'm going to throw something out there. What do you think about this? Make it an incremental step. Okay? Baby steps, right? Baby steps. Hey, how about, can we agree on this little piece of the puzzle? Can we agree on that? If you get agreement on that little piece of the puzzle, oftentimes you get agreement on bigger pieces of the puzzle. Okay? And sometimes then you get a cascading effect, and then next thing you know, everything's kind of pulling together, and suddenly the jigsaw pieces have all come together and you have your puzzle all figured out, right? But sometimes it takes somebody to make that first step. Why not you? Okay. I'm not a big proponent of stonewalling and thinking, well, if I just hold my position, cross my arms, and look all like I'm never going to say anything or do anything, I'll get my way. Well, that's like a little kid holding their breath. It doesn't really work. Okay. I mean, if you are in a negotiation, by definition, you are not going to get everything you want. And if you come into a negotiation with the attitude that I'm going to get everything I want, you are going to leave very disappointed, because the other side's simply not going to do that. It's all, I will say, I don't remember a time ever seeing that happen. That doesn't mean it never happened to me or that I never got everything I wanted. I just don't remember it. Now look, I'm getting a little older. You can see all the gray here. I don't remember things quite as well as I used to, and so it's possible I've forgotten. Some other things to think about while you're negotiating. What about some of the things that you might hear about, like offhanded comments people might make? Do those matter? Well, as I said earlier, it could matter, and you have to pay careful attention, listening carefully to the things people say. Even comments about somebody's personal life. You might get somebody on the other side, the other negotiator might say something to you that gives you a glimmer that they're experiencing some sort of problems in their marriage, for instance. I don't want you to misunderstand me. I'm not saying you should use that as a wedge and crank it and just try to jam that in every moment and try to use that against them. However, it may give you some insight into the character and the thought processes of this person. they may be a bit emotional. And so you may be able to kind of use that emotional charged upness, if that's a word, to your advantage. And frankly, as an attorney, if I'm representing a client and I recognize that the other side has got something going on that I can use to better my client's position, as long as I'm not doing anything unethical, I have an obligation at that point to say, I got to kind of use this. I don't like it. I may feel kind of, I'm not sure I feel great about it. Question and query whether, as a Christian, should I do that or not? It gets you into really tough territory. And so that's something to think about. Do I take advantage, as it were, of this person's weakness in negotiating because their mind is focused elsewhere? Well, maybe they shouldn't be there negotiating if their mind isn't on the process. And so it puts me in a delicate spot, but I think I have to try to use that. Ask questions. I've already said this once. You'll hear it from me again. Questions unasked are questions unanswered. If you don't ask, you don't know, right? So ask the question why, right? That's a good question to ask people because it forces them to tell you things, right? You say, well, why won't you move in my direction? Why is it that you believe this matter is worth, $10? Why is it that you think we should capitulate on the stock provisions that you've inserted here? Why? That forces an explanation because you can't just say yes or no and you can't give a one-word answer. It doesn't work for the most part. And so that's always a great way if you need information to get it out. Use open-ended questions as much as possible. Who, what, when, where, why. It's a good way to remember that, the W's. When you get close to the end, that's a good time to start using closed-end questions. That is, questions that assert the answer, okay? Or questions that are just yes and no. But leave those till the end. A couple other things I want you to think about as you are negotiating. Silence is a very, very impactful tool in your arsenal. And what that means is that you simply say nothing sometimes. And that was like 8 or 9 seconds. It's weird. You're watching this video and you're like, whoa, that's weird. He's supposed to be talking or doing something. You get the point, right? I will tell you an old story. And the reason I tell you stories oftentimes is not just, I love telling stories, so that's part of it. But the other thing is that the stories tell you something about what I've learned and experienced. There was this old attorney, I won't give his name. He one time called me. He called me, okay, about this case. And we get on the phone. He says, hey, Gus, this is, so-and-so. And he kind of talked like a deep Southern voice. I loved his voice. It was great. I loved to be a few octaves lower myself. And he says, we need to talk about that case. Silence. And so after a few seconds, I start talking because I can't stand it because he's not saying anything. He called me. I didn't call him. He called me. He got a lot of stuff out of me because I couldn't wait. I couldn't stand it. And instead of saying, well, okay, what do you want to talk about? I start babbling like an idiot. He got me. Again, then I knew, though, that he would do that. And from then on, when he called, I'd say, well, hey, what's up? What's going on? What do you need? What do you need? Something like that so that he would start talking. It's a funny story on me. But wow, it taught me the lesson of silence because wow, it works. Paralinguistic and nonverbal communication, just a few things to say about that very briefly. I'm not a big proponent of getting all wound up about whether somebody's crossing their legs, not crossing their legs. whether they've got their hands crossed or folded or pointed, or whether they're, scratching their face or tugging their beard. Look, I do this all the time. I've had a beard for years. It's just a thing I do. I do it all the time regardless. I could be anywhere doing it almost at any time. It has no reflection on anything. It means nothing. It doesn't. It just means that I'm just playing with my beard because that's what I do. So if you're sitting in a negotiation and you think, oh yeah, I've got Nelson figured out. Every time he does this with his beard, he does so and so. That's not. It may coincidentally be the case at that moment, but I'm telling you, the next time you see me negotiating, it's not going to be the case because I'll be using my right hand that time instead of my left hand. Well, uh-oh, what do you do now? I said, don't read too much into that kind of nonsense. That's my take on it. Whether people will look you in the eye, okay, yeah, maybe that means something a little bit, but a lot of people just don't like making eye contact. We'll talk about cultural differences later on in another lecture. Look, some cultures don't even care for eye contact. So body language, again, not necessarily helpful. Whether people sit straight up or whether they kind of slouch, every once in a while that might mean something. I will tell you that I remember a friend of mine cross-examining a doctor one time on a witness stand, and the doctor, as the cross-examination went, slouched further and further down in his chair. And the reason he was slouching was because the doctor was really saying things that were patently absurd, and he knew it. And he was physically kind of slouching down in his chair. It was really kind of funny to watch. And it was a great cross-examination for that reason. Other than something like that, which rarely happens, I wouldn't put too much stock in those things. The other thing you got to remember is what's coming out of their mouth, because that's important. Because presumably, especially if you're negotiating verbally, again, we'll talk about email and texting and that sort of thing later. It's very important to recognize that what they're saying is really the most important thing, not kind of how they're saying it. As you can tell, I use my hands a lot. Well, what does that mean? I use my hands a lot. Does it mean I'm giving away something? Maybe, maybe not. Probably not. I tend to move my leg up and down with nervous energy. I've done that since I was a little kid. Again, I'll tell you another little silly story on myself. I'm sitting at a St. Petersburg Cardinals game in 1971. My dad and my grandfather made my grandfather showing me how to do a baseball scorecard. And I'm kicking. There are these aluminum benches, and you just sit on the bench. And see, because my office is so messy, I just knocked over a bunch of papers. Anyway, so I'm sitting on the bench, and I'm kicking the bench in front of me. And there's a guy sitting on the bench in front of me. He turns around and looks at my dad, and he says, "Hey, tell that so-and-so kid to, cut her, blah, 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 or I'm going to do something about it myself." And so my dad, who's kind of like not a guy who likes confrontation, is kind of like, "Hey, just chill out." My grandfather says, "Hey, you, shut up. Leave him alone. He's just a kid." My grandpa didn't put up with stuff. It was great. But my point is, not that my grandpa was great, although he was. My point is that, look, I've got nervous energy and I'd kick the bench. You can't read too much into those things because you might be reading into these kind of things nothing. Okay? So just be very circumspect about getting caught up in that kind of thing. That's all I'm saying. I'm not saying it doesn't ever matter. I'm just saying be careful about it. Final thing, very briefly, and then I'll be done and I will have doubled my time. I'm really sorry about that, but off-the-record discussions, and I do want to talk about this because these are very important. Oftentimes in a negotiation, you and the other negotiator know that you are closing in, and you both sense that the end is nigh. However, you haven't quite gotten there, and neither one of you maybe has a clear idea about exactly where things need to end up. Oftentimes, it's appropriate to then sort of say, listen, and now look, you got to trust this person. If this is someone you don't know, you can't do this. The only time you can have an off-the-record conversation with the other negotiator is when you know them and when you trust them. Okay? Otherwise, I don't recommend this. But you simply say, look, off the record, I'm not telling you, this is not an offer, whatever. This is not anything. This is just me talking to you and telling you that if we can work out, points A and B, I think we can get point C done, and I think we can wrap this up. Just letting you know, in points A and B, maybe you're very close to getting those done, and then point C is something your client just doesn't care about very much. It's okay to have those kind of conversations, and quite frankly, I had those conversations all the time with attorneys I trusted to be honest with me. And those can be very, very helpful, because oftentimes what you find out in this sort of off-the-record mode, and that is you're not making any official statement, you're just sort of feeling each other out, particularly when you're close to resolution. Oftentimes you'll find that it's very helpful to kind of have that sort of, hey, I'm not really, this isn't official, but it could be, kind of conversation with the other side. All right, well, that's it for Unit 3. I know it went very long. Thanks for your attention, and well, we'll talk to you.